It's great to be back here hosting. Glad to be with you for my first program of November. For all of you who were observing Veterans Day yesterday, I'm hopeful it was an opportunity to um, honor those who have served. And we are looking forward to also, in today's program, talking with you about a variety of topics, including some of the ramifications as we're beginning to parse them out of last week's elections. And why don't we first, though, please go to the agenda slide. Thank you, Kathy. And so I will be, spending just a couple of minutes talking through what we know thus far with regard to the election. It really, relates to all of you and your businesses. That's, what we're focusing on. And then after that, Arthi Shandan will be back with us. She's in our Buffalo office, and we're thrilled that she'll be on the program again to focus on NLRB activity, a decision affecting labor organizing at religious institutions. John Harris, who sits 2 doors away from me here in Manhattan, is also someone who's been on the program a number of times, and we're glad to have him back. John will be talking about the biggest employee benefits cases of 2024, and again, how they affect all of you. Liz Heifetz, who sits also nearby me here in New York City, and who focuses on immigration, will be working through with all of you updates in terms of I-9 and compliance. Lots to learn there, and I'm looking forward to hearing what Liz has to say. And then our final presentation for the program today will be from Ruth Clement. Ruth is actually new to the program and sits in our Melville office, and she will be focusing on aspects of bankruptcy that are part of her practice, which is an interesting one we'll talk about in a little bit. But for now, let me get into the content that I wish to review with all of you. So if you go to the next slide, please, Kathy, and the one after that would be great as well. So all of you, I'm sure, have looked at this map before. Of course, we will be having a change in leadership in the White House with President Trump returning to office. And the map here is, as it is settled with 95 and change of the estimate, or rather of the votes counted as estimated, excuse me. So this is pretty much as it will be. And we just wanted to remind you of this context because, as people say many times over, and it is true, elections have consequences. So next slide, please. Let's start to talk about what some of those are. Here in New York State, there were a variety of U.S. House of Representatives elections that, are listed in some detail on the left-hand column. But what I really wanted to focus you on are those where I have arrows. Those are elections where it wasn't an incumbent retaining a seat, but where we have someone new in the seat. And some of the most contentious or otherwise closest races, the ones that got some national attention based on, as has been quite extensively reported, the relative losses among Democrats in New York State in the 2022 midterms. What you see is a Republican win in the 1st district, as well in the 17th district. The balance of the seats that were in some level of doubt all went Democratic. That will be something that is at some level anomalous relative to the country, where there were many more Republican seats picked up. And, we're seeing changes in the complexion both of the Senate and the House. The House is not quite settled, but it looks like it will likely be Republican. The Senate, we know, certainly will be. Next slide, please. And so the outlines of the new administration are beginning to take shape. And on this list, I've highlighted just a few of the individuals whose names have been in the news. None of this is official. It's just what we are hearing as President Trump's wish in a number of different instances. Former Rep. Lee Zeldin from Long Island, who ran, of course, for governor in 22 and lost rather in a close race with Governor Hochul. It'll be the Environmental Protection Agency that Representative Zeldin will be leading, and in all likelihood. And then as well, Elise Stefanik, who is, of course, a representative as well from New York, will be the administration's ambassador to the United Nations. Senator Marco Rubio from Florida is being mentioned as likely Secretary of State. If all goes forward, that will mean that there will need to be someone to replace Senator Rubio in the Senate in Florida. And then a bit of a wild card is Robert F. Kennedy Jr., who of course ran a presidential campaign that concluded a few months ago with an endorsement of President Trump. And it is clear from both the statements of President Trump as well as Mr. Kennedy that he will have a role in the healthcare administration through the administration. Exactly what that looks like is yet to be determined. But anyway, these are just some of the names that are being mentioned. And, of course, some seats require congressional approval. Others are nominations outright that can go forward. And as this continues to become clearer, we will keep all of you up to date because, again, these changes do affect and otherwise matter to your businesses, and we want to make sure you have actionable material. But that's all we're going to say about the elections for now. We'll be back with more content over the course of additional programs in November and December of 24. And of course, before the inauguration of President Trump for a second term. But for now, let me turn to our first presenter for the afternoon. And that is Arthi Shandan. And we are thrilled to have Arthi back with us. Arthi is associate based in our Buffalo office, who has spoken to you a number of times over about labor and employment matters, which are really at the core of her practice, and is here to discuss an NLRB decision that impacts labor organizing at religious institutions. So, Arthi, I'm really glad that you're back with us, and I look forward to learning with the audience. The floor is yours.
Thanks so much, Gabe. I appreciate it. So as Gabe mentioned, I'm here to talk about a recent decision by the National Labor Relations Board. And this decision dismissed all complaints against St. Leo University, which is a Catholic university located in St. Leo, Florida. So this decision actually affirmed that St. Leo is exempt from the NLRB's jurisdiction due to its religious affiliation. So just to kind of summarize this decision, a little bit of background. So St. Leo University withdrew its union recognition, unilaterally, and also changed certain terms and conditions of employment for its faculty. So, of course, this was challenged, and the NLRB upheld St. Leo's decision to withdraw union recognition, and it cited to its previous decision in Bethany College, which provides that religious institutions meeting certain criteria are not subject to the NLRB's jurisdiction. Specifically, the NLRB found that St. Leo University, I apologize, met the three-prong test for exemption. And this three-prong test, which was laid forth in the Bethany College decision, basically states that one, the institution has to hold itself out to the public as providing a religious educational environment. So that might be through promotional materials, if they go to high schools and kind of talk to students about their school and what they do. The second prong is that it is organized as a nonprofit. And the third prong is that it is affiliated with a recognized religious organization. So the board concluded that St. Leo University, as a Catholic university with a long-standing religious tradition, they concluded that they were exempt from the jurisdiction of the National Labor Relations Act, or the NLRA, and therefore exempt from the jurisdiction of the board. So they held, just in sum, that their actions in unilaterally withdrawing their union recognition and changing the terms and conditions of employment for their employees was permissible. And I think it's really important to note the potential implications that this can have, particularly for colleges and universities. So, by affirming the broader application of these exemptions available for religious institutions, the decision has a significant impact on how religiously affiliated colleges and universities manage labor relations. So colleges and universities that meet the exemption criteria can enjoy, greater autonomy in dealing with labor matters, as they did here, including the option to just withdraw recognition of faculty unions or alter employment conditions without engaging in the whole collective bargaining process. Um, Also, this decision really underscores the importance of clearly articulated and visible religious identity for institutions that wish to utilize this exemption. So the NLRB highlighted that St. Leo University's consistent public expressions of its Catholic identity was a key factor in its decision. So as such, colleges and universities wishing to rely on this exemption should ensure that their religious character is evident in their policies and their mission statements and their websites, community engagement, kind of like those marketing materials that I mentioned earlier. Religiously affiliated colleges and universities might also consider reassessing their relationship with faculty unions in light of this decisions. So, I think this decision shows that, you can unilaterally withdraw recognition, and it will, it could be considered legally permissible, but that should also be approached with caution, and it might still be subject to challenges by unions or individual employees. So institutions should prepare strong evidence supporting their religious affiliation and adherence to that three-prong test that I mentioned earlier, if they choose to take that route. I know something oftentimes we say is, document everything, and that certainly stands here, especially for those institutions, excuse me, that want to utilize this exemption. And finally, to ensure that they qualify for the exemption, excuse me. I apologize, I've been sick. Religious institutions should evaluate how they present their religious identity to the public and to stakeholders. So, as Gabe mentioned, the election has the ability to affect the NLRB and how they view these decisions. So, if you have any questions, please feel free to reach out to me or anyone else in Bond's labor or higher ed group.
Thank you very much for your feedback, and Arti, continue to feel better. We have all been sick, and with any luck, a couple more days and you'll get over that hoarse throat. But thank you all the more for pushing through and providing some quite useful information. Why don't we switch to our next presenter now? And that will be John Harris, who sits, as I mentioned, just 2 doors down from me. And this is an important opportunity to remember that ERISA, which is employee benefits, and really the federal schema that controls much of it, is turning 50. Bond has been focusing on that, including through a variety of events, and this is an extension of that. I really look forward to hearing from John about what some of the highlights are. His presentation will be focusing on 2024 employee benefits cases, but it comes in that context of the 50th anniversary. John, I just want to remind all of you, is an attorney who focuses on employee benefits in his practice, and I've had the pleasure of working with John on a number of matters, and really look forward to hearing about what, John, you have to say here today. So the floor is yours, and thank you so much for taking this time.
Great. Thanks a lot, Gabe. Thank you for that wonderful introduction. Yes, indeed, ERISA is 50 years old, and for its 50th birthday, we got some litigation hits to go over. We're going to go over the biggest cases of this year. Believe it or not, we're getting down to the end of 2024. So you'll start to get all these, kind of lists about, best songs of 2024, but we're going to go over the best litigations, or at least the ones that are most significant for your practice in employee benefits in 2024. Next slide, please. So we're going to go over what's happened in plan design, what kind of cases have come up in that area. And then we'll move on to where the lion's share of cases focused on, which is on plan administration. How you actually run your plan operationally, whether you're paying the correct amount of fees, how you're applying plan forfeitures. And finally, we'll go over one of the biggest litigation events of this year, which is not only exclusive to ERISA, but affects really all areas of law that are governed by a lot of federal agency regulations, because the Supreme Court this year, in a decision named Looper Bright, changed how we defer to federal agencies' interpretations of the law. And we'll conclude this presentation with how you can mitigate your litigation risk going forward. So next slide, please. So the first topic is plan design, and the big issue under this topic is mandatory arbitration. Historically, it was impermissible to require a plan participant, an employee of yours who participates in your retirement or welfare plan, to arbitrate their ERISA claims, specifically their breach of fiduciary duty claims. And it was always held that you had to allow the participant to file their lawsuits in federal court. That changed in 2019, and it was a pretty dramatic shift in the case that's highlighted under the first bullet point, Dorman versus Charles Schwab, which allowed plans to start to insert mandatory arbitration clauses for breach of fiduciary duty claims. And as a result of that, companies started to routinely include these mandatory arbitration provisions in their plan documents. Now, since then, the courts have been trying to fine-tune the details of this new view on arbitration clauses in employee benefit plan documents. And it's been a little bit contradictory. They're still trying to figure it out, and I think this is best elucidated by some decisions that were in tension with each other in the Third Circuit this year. So the first case is Henry versus Wilmington Trust. And in that case, they held that you can have a mandatory arbitration clause in your plan document requiring participants to litigate in an arbitration as opposed to federal court. But you cannot include a class action waiver in those arbitration provisions. So in this Henry case, the plan document had a class action waiver that was so integral to the arbitration provision that the court said we cannot sever this class action waiver from the broader arbitration clause. Therefore, we're invalidating the entire arbitration clause. So that case basically is saying that if you want to do arbitration, you have to preserve class claims for plan participants. But then in the same decision issued a little bit later, the final bullet point, Berkelhammer, the court had a case where participants had brought a claim against the trustees of the plan on behalf of the plan. It wasn't explicitly a class action in the way that it's done under the rules of civil procedure, but it was done on behalf of the plan, which is a way you can do it under ERISA Section 502A subsection 2. The court said that even though that this is really looks and feels like a class action and that it's being brought on behalf of plan participants against the plan, it's qualitatively different because the plan had actually, the trustees of the plan, by and through the trustees who were being sued here, had assented to the arbitration clause. So they allowed the claim on behalf of the plan to be arbitrated. This is extremely nuanced, and I think that the takeaway from all these cases is that it's too risky to include a class action waiver in your plan documents right now, but courts are routinely approving mandatory arbitration provisions. Next slide, please. So now let's move on to the actual administration of the plan. Some of you may be aware of the historical practice of class action lawyers filing excessive fee litigation class actions against especially retirement plans. They often allege that the retirement plans pay investment managers too much money, or the actual investment products, the securities themselves, have administrative fees, like for a mutual fund, that are too high, or the administrative expenses are too high. What's starting to happen now is that this type of litigation is moving towards also welfare plans, the health insurance that you provide to your employees through your employee benefit plan. In 2021, there was an amendment that said that welfare plans have to disclose what their group health plans pay to service providers, including brokers, record keepers, pharmacy benefit managers, and third-party administrators. Recently, pharmacy benefit managers have come under intense scrutiny by the United States Congress and also the press. The New York Times has launched a multi-week investigation into pharmacy benefit managers and how they structure their fees, and the investigation is not favorable to pharmacy benefit managers. They structure their fee structures in a way that is very obtuse, difficult to understand, and once you understand it, it seems very unbelievably favorable to the pharmacy benefit managers. So going forward, it's good to look at your service provider contracts with these service providers to ensure that you have reasonable fees to protect against this kind of litigation. But the courts are also providing you with some new defenses as well. In a case that got decided this year, Cunningham versus Cornell University, the court held that we're going to change the burden for these cases at the initial pleading stages. Originally, when a participant filed a lawsuit, all they had to say was that the fee was unreasonable and it was a prohibited transaction. And then the burden of proof was on the employer to actually prove that an exception under ERISA applied, that the payment was reasonable. The Second Circuit in Cunningham flipped the script and is now saying that at the initial pleading stage, in filing the complaint, the plaintiff, the participant, has to provide a plausible pleading fact that the fees are unreasonable. It's crazy that that was not always the case, and I think that with this new standard, you're going to see decreased litigation, though. Next slide, please. Another major issue that kind of shook the employee benefits attorneys and professional world was these 3 cases on plan forfeitures. Since 1971, the IRS and all employee benefit plan professionals have used plan forfeitures, which are benefits that never vested in a participant that reverted back to the plan. You were always able to use them for paying administrative expenses, increasing benefits for participants, or, and this is the most important one, decreasing the employer's contribution obligation. So you can use it for employer contributions, basically. That's been the practice for 50 years, and no one has said anything until this year. There are 3 class actions filed where the plaintiffs are alleging that using forfeitures for decreasing the employer contribution obligation is a prohibited transaction because the employer is self-dealing and it's taking away the benefits that should be used to increasing the benefits of the other participants. The ERISA community, myself included, thought that these cases were going to be dismissed out of hand. We were all wrong. It seems that these cases are going to be surviving the motion to dismiss stage and then get adjudicated on the merits. So we're following these cases very closely. In the meantime, my recommendation is to explicitly state in your plan document that you are allowing the plan administrator to apply forfeitures to pay employer contributions. That should provide you with a defense to these actions. Next slide, please. This is also a change in the regular practice of things. If you have a document, if you have a defined benefit plan, like a pension plan, usually you're able to transfer that that obligation of defined benefits to an insurance company by purchasing an annuity contract. And it's a routine transaction. Well, there are 3 cases filed against AT&T, Lockheed Martin, and Alcoa Corporation, where we see that plaintiffs' attorneys are filing class actions alleging that purchases of annuity contracts from annuity providers that are owned by private equity investors or private equity firms is a prohibited transaction because it breaches the fiduciary duties of the trustees of the plan, because it's not a safe investment. This is a new development. Usually, you don't look at the ownership structure necessarily of annuity provider, and when you're deciding to de-risk your pension plan, the IRS has put out a list of things you do consider, and this is not one of them. But again, these cases are still being litigated and not being dismissed. Next slide, please. This is a new issue on plan administration that could become a major issue for welfare plans. The last couple of topics have been about welfare, about retirement plans. The United States Department of Labor has identified what's called cross-plan offsetting as an enforcement priority for this year. And what that means is cross-plan offsetting is when a claims administrator, like an Aetna or a Excelis or United Health Group, like you see on the slide here, they will overcharge a healthcare provider for with the assets of one plan or through the one plan, but then they because they need to recoup an underpayment to that same provider through another plan. So this practice is by the claims administrator to balance bill across their various customers to make sure they get a balance bill from the provider at the end of the day. This practice of using assets from different plans to balance the claims administrator's books is being identified by the Department of Labor as a prohibited transaction that does not it's self-dealing, they're saying. They're also saying that if you are a self-funded welfare plan, meaning you pay the medical claims directly out of your general assets, the employer or the plan sponsor could be liable for a breach of fiduciary duty by failing to monitor the claims administrator that has engaged in this cross-plan offsetting. So the best practice here is to make sure that your plan document, that your contract with your claims administrator says, we will not engage in any cross-plan offsetting. Next slide, please. And then finally, the end of deference. There's this new case that says the deference doctrine used to be essentially if the courts felt that the statute was ambiguous, you would defer to the agency's interpretation. That deference is no longer the rule. Instead, courts are supposed to apply traditional rules of statutory interpretation to resolve that ambiguity. And it's unclear how courts are going to be interpreting agency rules and regulations. But they do seem to be looking to consistency with prior agency proclamations, the validity of the reasoning underlying the regulation, and the strength of the evidence underlying the regulation. I think this is best demonstrated by looking at 2 new rules from the Department of Labor and the IRS. For the Department of Labor's retirement security rule, it basically changed the definition of what's known as an investment fiduciary, an investment advice fiduciary, in a significant way that departed from the previous IRS announcements. In contrast, the recent 2023 IRS proposed forfeiture regulations that do allow employer contributions to be funded with such forfeitures, those align with all the regulations from the IRS since 1971. Under the new deference regime, it seems that the 2023 regulations would be upheld or deferred to, whereas the new retirement security rule that departs from the other one that's being litigated in those two cases I have there, that's probably not going to get deferred to. So next slide, please. So now we have a final slide. It's how you're going to mitigate the litigation risk. Look, like I said, for plan design, remove the class action waivers, keep your arbitration clauses, include a plan forfeiture use provision, explicitly stating that you can have employer contributions funded by forfeitures. I'd also put in there that you should put in a rule that there's no cross-plan offsetting in your service provider contracts. And then finally, for the plan administration, you want to, have a procedure in place where you're documenting that you're reviewing all of these policies and the recent cases, and you're, as Arati said, documenting everything that you are meeting and addressing these issues to ensure that you're complying, that a reviewer of fact would say that you comply with fiduciary duties. And look, the deference issue with the agency regulations, it's uncharted territory right now. So if you're thinking about making a decision based on an agency regulation, I recommend you speak with counsel. And we're here to help. So thank you for your time. And I defer to Gabe.
Thank you very much, John, for that helpful presentation. And let us turn to the last two presenters that we have for the afternoon. The first of whom will be Liz Heifetz, who is back on the program also from our New York City office. And Liz, who is an immigration attorney, has lots of knowledge and background on the I-9 process, and thought that it would be timely to speak with all of you about it. She's been getting a lot of questions about I-9 activity in her practice. So Liz, what is really important here to be focusing on? I look forward to learning along with the audience.
Sure, thanks, Gabe. So I wanted to just kind of bring everyone's attention to just general I-9 policies. We're entering, the last quarter of the year. Also, the reason I wanted to kind of just talk about the highlights here with respect to I-9 is just generally with any administration change, there's definitely been the thing that there's been a lot more worksite enforcement. And so it's critical to have all your I-9 policies up to date. You'd be absolutely in compliance with them. And so just kind of walking you through and maybe reminding you, if you already know, of certain things to keep in mind, to look out for, and just kind of just start doing, just so everyone's in kind of good shape. You should be doing it anyway, but sometimes it just falls under the radar. So just good to have kind of a refresher on that. Kathy, can we go to our first slide? Thank you. So first things first, as you know, there was a new form that came into effect last year. So first kind of thing to keep in mind is make sure you are using the right form. Sometimes there are discrepancies, and if you're used to using a form and then you don't realize there's an update, you go by using what you already know. And unfortunately, even though it's kind of a procedural kind of mistake and it was not intentional, they will hold that against you if an audit is given to you by DHS. So make sure you're using the right form. I have listed the site there to double check and make sure it's there, but just make sure that is being taken care of. Secondly, make sure your internal I-9 policies are updated, especially if you're using remote verification. So, as you know, remote verification is permitted if you as an employer are using E-Verify, and if you meet the other requirements. If you don't already have E-Verify, I highly encourage you to consider doing it. It's a painless process. It's also very simple. It allows you a lot of flexibility. It helps you maintain compliance in a way, kind of keeps you in line when you review documents. And also it allows you to bring in certain employees that you wouldn't have been able to bring in otherwise. As an example being individuals who are, after school, finishing their degree programs, and they're in a specific field, in a science, math field or something like that. Without an employer having E-Verify access, they will not be able to get hired by you. So even if you're doing everything by the book, that is not someone you'll be able to bring on. So just some food for thought in case there's some employees out there that you really would love to bring on, something to consider. And it's also helpful to you. Thirdly is just generally start implementing annual compliance trainings for HR and onboarding teams, it will be supremely important to make sure that everyone is following new procedures, acceptable documents for verification and identity, and work authorization. It is possible that certain policies are going to change within the next 6 months to a year. It's possible on what is considered acceptable and non-acceptable. And, we will update you, if that should be the case. But just make sure everyone internally is aligned, because there have been situations where, information gets lost through, the hierarchical food chain, so to speak. And it's, unfortunately, once again, it's not intentional, but they will hold it against you if an audit is issued. And the other thing is just confirm your E-Verify policies. As you know that, E-Verify is voluntary with, exceptions for federal contractors and certain state mandates. More than 20 states, I think, currently require E-Verify for certain public and private employers. Those states I've listed here. So make sure if you fall under one of those categories, you take appropriate action. So bear that in mind, think about it, and make sure that all of that part is kind of taken care of. Kathy, can we go to the next slide? Okay. So with this in mind, I wanted to take, a couple extra seconds and talk about this internal audit. It's very tedious to do. I very much understand, why this sometimes kind of also falls under the radar. The bottom line with I-9, what is I-9? Why is it important? Is essentially the purpose is to show that an employer did not knowingly hire or continue to hire a worker that's unauthorized. That's kind of the bottom line. So with this in mind, a good faith effort would always be a company's affirmative defense to a claim of knowingly employing an undocumented worker. So, and it could be something that just fell through the cracks, or, the wrong document was something like that. But a good faith defense is always viable. It helps with the kinds of fines that you might be slapped with, and it just generally it will never hurt you if you do one of these audits. And like I mentioned earlier, with a new administration change, there will be likely much more worksite enforcement. And so to avoid any potential, fees slapped on your wrist, or DHS conducting very tedious audits, if you haven't been doing internal audits, you should be, in the habit of just doing them every 3 years. You should absolutely start doing that now. Regardless of the version of the Form I-9 in circulation, this always has to be done. Can't encourage it enough. It helps with if there's a company merger, or there's an acquisition or corporate restructuring, some things fall through the cracks, and it's very, very good to just have some system in play that allows you to kind of do these audits for yourself, because just by virtue of you doing these audits, it kind of shows a good faith effort that otherwise wouldn't be there. And like I said, in the past, ICE has really been appreciative of companies who have shown this and been able to show this. So just remember this kind of moving forward, and if you have additional questions with respect to how best to conduct audits, and any kind of assistance we can give, we are happy to give. Just kind of think about this as you move on into towards the end of the year next year. Kathy, can we go on to the next slide? So this is just kind of, I just wanted to show you the chart that they use, and kind of things to keep in mind as, when you're thinking about audits. Sometimes, with good faith, you can recognize a substantive issue, turning it into a potentially procedural one, or even get rid of it altogether, because some things you don't even think about, and it's not intentional, but it can be the difference between $48,000 and $0. So just food for thought. Kathy, next slide, please. And so now I wanted to kind of just talk to you generally about a couple updates specific to the kinds of documents you are looking at when you're doing your I-9s. There's a bunch of these that come out fairly regularly, and updates to these about what is accepted, what is not accepted. And so I just wanted to bring your attention to some of the main ones that I've been getting a lot of questions about generally, and what to kind of look out for. So first of all, USCIS extended validity of expired permanent residence cards from 24 months to 36 months. As applying for a renewal permanent residence card, depending on which category of permanent residence you're in, could take forever. The government has recognized this. And as a result of that, they kind of, allowed employers now to accept a receipt notice after the renewal is filed, along with the actual permanent residence green card, to use that as a source of work authorization. So food for thought, you can definitely accept that. This one, some people, is not going to be relevant to everyone. Just, for certain Lebanese nationals, their work authorization, they're able to extend it through January 25th, 2026. Again, this is kind of specific, but if you have additional questions, do let me know. The other thing to bear in mind for your own records, because you should be keeping diligent records, January 5th, 2025, E-Verify records are scheduled for disposal. So on January 6th, USCIS will dispose of everything. So if there's anything you want to keep in mind, and I highly recommend that you do, they'll dispose of anything that's more than 10 years old. So save it if that is still important to you. And I would recommend at least within the 5 years, even if the employee has left, keep records. If you have questions, ask. But generally, you should bear that in mind as you kind of move forward. Kathy, next slide, please. This one, again, kind of specific, but all you need to know here is, the situation with Ukraine has now, with people coming in and getting work authorization pursuant to the Uniting for Ukraine program, has been extended to those that entered before September 30th, 24. For purposes of work authorization, there's two ways to verify this. One is they have work authorization incident to parole, which means as soon as they enter, they have an I-94 that can be pulled up online. And if they have entered before September 30th, 2024, you should be able to accept the I-94 without an EAD card. Alternatively, any I-94 that has a DT symbol, you can accept those as well. Will be, kind of acceptable. And kind of a couple last things to just bearing in mind is, USCIS extended I-9 expiration date. This is specific to forms. I could talk, for 20 minutes just about this. Ask questions if you have questions with respect to this. Just know that they have extended the expiration date of the specific edition form that they're using, but make sure you're using the right edition form. And the last thing I just want to throw out there, I've mentioned this before, I think on a different webinar that I might have done, but if you haven't already signed up for the image program, you should, because this allows you, it's a partnership with DHS that allows you to have audits, done to your company without any penalties. So because of the agreement, all penalties are waived. So something to consider in case, you're thinking that you might need some assistance with just managing a good I-9 compliance, policy protocols, so on and so forth. So that's just kind of a nutshell of what to keep in mind. Let me know if you have any additional questions, more news to come, in the next few months, but just maintain great records and be compliant with everything as to your best of your ability. All right, Gabe, I'll just give it back to you.
Liz, thank you so much. We appreciate that very helpful overlay of I-9 activity. And certainly we expect there'll be movement in the space in the next month. So please come back. We ask all of you to, stretch just a little bit in terms of the time you're allotting to this program, because we don't want to have you miss an important presentation from Ruth Clement, who's an associate in our Melville office, who, among other accolades, not only has her law degree, but also her MBA. She's a certified public accountant and a certified internal auditor. So Ruth really knows her stuff. And Ruth is here to talk about some issues in bankruptcy that have been important in her practice. And we're thrilled to have Ruth on the program. Thank you for joining. This is Ruth's first, but I'm sure will be one of many presentations to come. And Ruth, the floor is yours.
Okay, thank you so much for that warm introduction. So this last topic is on bankruptcy law, and we're going to be talking about pre-petition unsecured claims versus post-petition administrative priority claims. Now, I know that that is a lot of words, and it sounds a bit overwhelming, but I promise you it is not as convoluted as it sounds, and I'm here to break it down for you. What I want to focus you on is pre-petition versus post-petition claims. And just like the plain language meaning, pre-petition refers to before the petition, and post-petition refers to after the petition. And what is the petition? The petition is the date in which the debtor files their bankruptcy petition in the court of equity or the bankruptcy court. And what is a claim? A claim is a right or an entitlement to receive payment, to collect on a debt, or to receive compensation for services provided or goods received. Now, why is it important that we distinguish between pre-petition claims versus post-petition claims? Well, under the bankruptcy code, those two categories of claims receive different treatment. And we are going to talk about the difference in treatments between those two claims. Next slide, please. So we're going to talk about, from the supplier's perspective, the implications of when a customer files for bankruptcy. Now, if at the time a bankruptcy petition is filed, there is an outstanding receivable, meaning a supplier has sold goods to the debtor and is now waiting to receive payment for that sale, and a bankruptcy petition is filed by the debtor, well, that gives rise to a pre-petition claim. And that simply means that the claim was outstanding before the petition was filed. Pre-petition claims are generally, and we're speaking in generalizations here, are there exceptions? Yes, there are. But with the 10 minutes we have allotted to this presentation, that's going to fall outside of the scope of this presentation. But generally speaking, pre-petition claims are treated as general unsecured claims. And what does that mean? A general unsecured claim has a low priority in terms of payment. If you think about all the costs that need to be paid in a bankruptcy proceeding, you have to pay attorneys, you have to pay the trustee, the government wants to be paid for any taxes, fees, or other charges outstanding. There's a long list of payments that have to be made. And if you're low in that priority, the likelihood of recovering the full amount owed is very low, if you recover anything at all. So to be in the category of a general unsecured claim is undesirable. And we engage in this legal fiction where we separate the debtor into two. And we look at them from a pre-petition phase and a post-petition phase. And that pre-petition debtor has transactions in the pre-petition phase, and those transactions are treated separately from the post-petition debtor, which is also called the debtor in possession, or DIP. So why is that important? We now know that pre-petition claims are treated pretty much unfavorably. They're treated as general unsecured claims. But how are post-petition claims treated? Well, let's talk about that next. Next slide. So a transaction that occurs between a third party, a supplier, and the DIP, meaning the debtor in possession, a transaction that occurs after the petition date gives rise to a post-petition claim. Now, again, this is all basic logic. If the transaction occurs after the petition, it gives rise to a post-petition claim. And post-petition claims are generally treated as administrative expenses under the Bankruptcy Code, Section 503B1A. And what does that mean? What are the implications of being treated as an administrative expense? Well, first of all, it means that your payment will be made in full. And it also means that your payment is entitled to priority ahead of pre-petition unsecured claims. Now, you may be asking yourself a logical question. why is such favorable treatment granted to the post-petition claimant when the pre-petition claimant acted in good faith? They entered into a normal business transaction in the ordinary course. Why are they relegated to the position of an unsecured general claimant that's probably going to collect pennies on the dollar or nothing at all, and the post-petition claimant receives priority? Well, if you think about what happens in a bankruptcy, when a debtor files for bankruptcy, the natural reaction of companies is to run in the opposite direction. They don't want to be affiliated with that debtor company. And the bankruptcy code strategically creates incentives to ensure that companies are willing to supply product or to extend credit. Because when we're talking about a Chapter 11 reorganization, I'm not talking about a Chapter 7 liquidation where the goal is to sell all the assets to the highest bidder. But in a Chapter 11 reorganization, the goal is for the debtor to eventually emerge from bankruptcy and to continue on as a viable company. There's a going concern. And the chances of continuation are adversely affected if there's no company willing to do business. So by giving this priority claim to post-petition claimants, to give them assurance that they will be paid in full and with priority, that encourages the business to continue in its normal course. Next slide. So I just quickly want to talk about some pitfalls, right? Because it's not automatic that just because a component of your transaction may have occurred after the petition date, just because a portion of your transaction occurs after the petition date doesn't automatically create an administrative expense priority. What do I mean by this? Well, the courts in the Second Circuit, they use a two-part test to determine whether a specific claim qualifies as an administrative expense. Now, this is not an either or, this is an and. So both of these criteria need to be satisfied in order to qualify as an administrative expense. The first is that there must be a post-petition transaction, making it a transaction between the debtor in possession, the DIP, and the creditor, and the estate must receive a benefit from the transaction. Now, this sounds like a low bar to clear, and you would think it's simple to satisfy both criteria, but it's not always that straightforward. Next slide. If you think about what a post-petition transaction means, that means, remember we said before, we engage in this legal fiction. Any transaction that happened with the debtor before the petition date was a transaction with a different entity. That was the pre-petition debtor. Only transactions that are engaged in after the petition date are transactions between the third-party company and the DIP. So if my shipment happened after the petition date, or the debtor hasn't paid until after the petition date, that doesn't mean that my transaction is a post-petition claim. Because if that purchase order was raised before the petition date, or if the contract that gave rise to that transaction happened before the petition date, normally a significant time before that petition date, well, that transaction, even though it was completed after the petition date, was in connection to a contract that was initiated before the petition date. So the timing of the payment receipt may not be as consequential as the date that the contract was initiated. And then the second criteria on benefit received, in the bankruptcy code, it talks specifically, it uses the words actual and necessary expenses for the benefit of the estate. And this requires that the estate, the debtor's estate, receives a real benefit from the transaction. A potential benefit is not sufficient. And it is the proponent of the administrative expense claim that must prove that they are entitled to receive that benefit and have provided a benefit. So it's important to keep those two definitions in mind when considering whether the claim qualifies for administrative expense treatment. Thank you.
And thank you very much, Ruth. So appreciated this walkthrough of these important issues in bankruptcy, and clearly for clients who are either themselves navigating bankruptcy, which we hope does not happen, but sometimes does, or otherwise engaging with an organization that is itself contending with it. Ruth and other attorneys in the firm are certainly available to give you a hand. So I know we're over time. We really appreciate your willingness to stick with us. If you have questions for any of the presenters, their emails and other information are on the slide that's on your screen. I will be back with you in 2 weeks. That'll be the 26th, just before Thanksgiving. In advance of that, Kristen Smith will be with you on the 19th. We thank you as always for your loyalty to the program. If there are ever questions or concerns or anything you'd like to bring up at all, feel free to reach out to me, and more than happy to discuss. In the meanwhile, wishing you all a terrific afternoon and day ahead. Be well.